Testimony is underway in the third week of the criminal hush money trial involving former President Donald Trump. Today, the judge in the case held Trump in contempt of court for violating a gag order. Judge Juan Merchan says Trump violated the order not one, but 9 times and fined him, $1,000 each, total of $9,000. CBS News correspondent Errol Barnett is following this for us outside the courthouse in Manhattan. Errol, you've been there day in and day out. Talk to us about this decision today. This is new news this morning, and the warning to Trump that it's not just about paying fines. He could end up in jail for this.
That's exactly right, Lilia. Judge Juan Merchan now instituting some level of punishment to former President Donald Trump for what he says is a clear violation of 9 instances of the judge's gag order. And as a result, the former president, will pay $1,000 per violation. And he has apparently until 2:15 Eastern to remove the corresponding Truth Social posts and remarks from his campaign 2024 website in order to be inside the lines of what the court will allow. He cannot intimidate witnesses.
Okay, so something absolutely massive just happened at the Supreme Court, and I need you to understand why this could fundamentally change the balance of power in our government for decades to come, because Trump is absolutely losing his mind over this ruling. And for once, I actually understand why he is so furious about what just went down. This is not one of those stories where Trump throws a tantrum over something minor and we all roll our eyes and move on with our lives like we have done so many times before. This is a genuine constitutional earthquake that has implications far beyond just this administration and far beyond just the people who are paying attention to politics right now. The Supreme Court just made a move that undermines one of Trump's most important legal arguments, and his team is scrambling to figure out what this means for their entire strategy moving forward, because they did not see this coming the way it happened. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
There's also one other aspect of the judge's order. Judge Juan Merchan also writes that the defendant is hereby warned by the court it will not tolerate continued willful violations of its lawful orders, and that if necessary and appropriate under the circumstances, it will impose an incarceratory punishment. So that is the threat of jail time to Trump if he continues to violate the gag orders. Now, for those keeping track at home, we have 9 violations of what the prosecution said were 10 violations, but last week they brought forth another 4. The judge is expected to hold a hearing on that decision on Thursday morning. So we're not out of the woods yet as far as Donald Trump's behavior as a defendant in this criminal case.
Well, let's get back to the trial now, Errol. The court also heard testimony today again from a bank executive, Guy Farrow. Why is he there? What did he have to say?
Well, if you remember, last week's star witness was David Pecker, former publisher of the National Enquirer, who says he was an admirer and a friend of Trump's, and he described the relationship of amplifying positive stories, suppressing negative stories. Now, additional witnesses have backed up some specifics. Gary Farrow.
Here is what you need to know right off the bat before we get into all the details and the legal complexities that make this story so significant for everyone watching. The Supreme Court has scheduled December arguments on whether to overturn a landmark 1935 ruling called Humphrey's Executor. And if you have never heard of that case before, do not worry, because I am going to explain exactly what it means and why it matters so much to how our government actually functions. This case has protected the independence of federal agency leaders for nearly 90 years by saying the president cannot just fire them whenever he feels like it for any reason he wants. It established that certain officials who run independent agencies have protections against removal, meaning the president needs a legitimate cause to get rid of them rather than just not liking them or wanting to put his own loyalists in charge of everything. Now, Trump has been arguing for years that these removal protections are unconstitutional and that the president should have absolute authority to fire anyone in the executive branch whenever he wants without having to justify it to anyone or go through any process. That has been a cornerstone of his legal strategy as he tries to reshape the federal government and put his own people in charge of agencies that are supposed to operate independently from political pressure and presidential interference. He wants to be able to walk into any agency, fire whoever is in charge on the spot, and install someone who will do exactly what he says without question or hesitation. The removal protections that have existed since 1935 have been standing in his way, and he thought he had the constitutional high ground in this fight based on how conservative the court has become. But here is where things get really interesting and where Trump's fury actually makes sense if you understand what just happened and how it affects his immediate legal position. The Supreme Court's decision to take up this case and the signals coming from the conservative justices suggest they might actually be willing to revisit that 1935 precedent, which sounds like it would be good news for Trump, right? You would think he would be celebrating and doing victory laps. But the way this is playing out has actually weakened his immediate legal position in several ongoing cases where he was relying on the argument that removal restrictions are unconstitutional. Lower courts have blocked some of his firing attempts, and now the legal landscape is shifting in ways that create uncertainty for his administration, even as the broader constitutional question heads to the Supreme Court for resolution. The ruling that came down lets Trump remove the FTC's sole Democratic commissioner, which again sounds like a win for Trump on the surface, and his allies are spinning it that way. But Justice Elena Kagan wrote a blistering dissent warning that the emergency docket is being used to transfer government authority from Congress to the president in ways that bypass normal judicial review and established procedures. She is essentially saying the court is making massive constitutional decisions through a shadow docket without the full briefing and argument process that these important questions deserve from a deliberative body. And she is not wrong about that concern. The implications of what is happening here are enormous, and they are being decided in ways that do not give the public or legal experts adequate time to understand what is at stake. Solicitor General D. John Sauer is going to argue this case personally, and that tells you how seriously the Trump administration is taking this fight and how much is riding on the outcome for their entire governing strategy. He is going to claim that removal restrictions infringe on the president's constitutional executive authority and that the 1935 precedent was wrongly decided and needs to be overturned after nearly a century. Some conservative justices have shown openness to this argument in previous cases, which is why Trump thought he had this in the bag and could count on a favorable ruling. But the procedural developments and the way the court is handling this have created complications that his legal team did not anticipate and that have left Trump reportedly furious behind closed doors about how messy this has become. This connects to so many other battles we have been following on this channel. Trump's efforts to remake independent agencies from top to bottom, his push for economic deregulation that requires getting rid of officials who might stand in his way, the ongoing fights over executive power that stretch back to his first term and continue through the 2024 election immunity debates and beyond. All of these threads come together in this Supreme Court case that will be argued in December. The outcome could reshape the relationship between the president and the federal bureaucracy in ways that affect every American, whether they realize it or not. So let me break down exactly what is happening and why Trump is so angry, even though parts of this ruling seem to favor him on the surface. All right, let us really dig into the substance of this Supreme Court battle, because the more you understand about what is at stake, the more you will appreciate why this is such a pivotal moment for American constitutional law and for the Trump administration specifically as they try to reshape the government. This is not just about one agency or one commissioner getting fired. This is about the fundamental structure of our government and how much power the president has over the people who are supposed to be running independent agencies free from political interference and presidential pressure. The implications extend far beyond Trump and will affect every future president, regardless of party, for generations to come. So let me start by explaining what Humphrey's executor actually established back in 1935 and why it has been such an important precedent for nearly a century of American government and administrative law. The case involved a member of the Federal Trade Commission who was fired by President Franklin Roosevelt simply because Roosevelt wanted someone else in the job, not because the commissioner had done anything wrong or failed to perform his duties in any way. The Supreme Court ruled that Congress could create independent agencies with leaders who have protection from at-will removal by the president whenever he decides he wants them gone. The idea was that certain functions of government, like regulating trade practices or overseeing financial markets, should be insulated from direct political control so that decisions are made based on expertise and evidence rather than political loyalty to whoever happens to be in the White House. This principle became foundational to how our government operates and has shaped the entire administrative state as we know it today. We have dozens of independent agencies: the Federal Reserve, the Securities and Exchange Commission, the Federal Communications Commission, the Consumer Financial Protection Bureau, All of these bodies have leaders with some form of removal protection that prevents the president from firing them just because he disagrees with their decisions or wants to put a loyalist in charge who will do his bidding. The theory is that these agencies make decisions that affect the economy and people's lives in profound ways. And those decisions should be made by experts who can operate without worrying that they will lose their jobs if they make a call the president does not like or that goes against his political interests. Trump has been waging war against this entire framework since his first term and has intensified those efforts dramatically since taking office again with a vengeance and a clear plan to dismantle these protections. His argument is straightforward and has a certain constitutional logic to it. The Constitution vests all executive power in the president. Therefore, the president must have complete control over everyone who exercises executive power on behalf of the federal government, and removal protections that limit the president's authority to fire officials are unconstitutional, violations of separation of powers as the founders intended. His legal team has been making this argument in court after court across the country, and they have had some success with conservative judges who are sympathetic to this expansive view of presidential power and want to roll back the administrative state. The problem for Trump has been that lower courts have not uniformly accepted his arguments and have blocked some of his attempts to fire agency officials who have removal protections under existing law. He tried to remove certain commissioners and was told by courts that he could not do so without cause, that the protections established in Humphrey's executor and subsequent cases were still good law, and he had to follow them whether he liked it or not. This led to intense frustration within the administration as Trump saw officials he wanted gone continuing to serve in positions where they could obstruct his agenda or make decisions he disagreed with. He does not like being told no by anyone, and courts telling him he cannot fire people he wants to fire drives him absolutely crazy. Now the Supreme Court has stepped in, and the signals are genuinely mixed in ways that explain Trump's fury, even though he is getting some of what he wants in the short term. On one hand, the court allowed Trump to remove the FTC's sole Democratic commissioner, which is a practical victory that gives him more control over that particular agency right now and sends a message to other commissioners. But the way the court did it, through the shadow docket, without full argument and briefing, and the way certain justices are framing the issues, has created uncertainty about where this is all heading and what the final rules will be. The December arguments on the broader constitutional question mean that everything is up in the air until the court issues a definitive ruling, and Trump does not like uncertainty, especially when he thought he had this fight won. Justice Elena Kagan's dissent is particularly important to understand because it captures what critics see as deeply problematic about how this is unfolding and what it means for our constitutional system. She warned that the emergency docket is being used to transfer government authority from Congress to the president without adequate consideration of the consequences for how our government functions. Think about what she is saying there. Congress created these independent agencies and gave their leaders removal protections for important reasons related to good governance and preventing political corruption of expert decision-making processes. Now the court is allowing the president to override those congressional choices through emergency orders rather than through the normal process of constitutional adjudication with full briefing and oral argument. The Brennan Center has been tracking these shadow docket decisions, and their analysis suggests a pattern of the court making significant constitutional determinations without the transparency and deliberation that such important questions deserve from the highest court in the land. When the court rules on an emergency basis, it does not have to explain its reasoning in the same way it would in a full opinion after oral argument and consideration of all the briefs. This leaves everyone, including lawyers, trying to advise their clients and lower courts, trying to apply the law, uncertain about exactly what the rules are and how far the new principles extend in practice. That uncertainty is a problem for the legal system and for anyone trying to understand what the president can and cannot do. Solicitor General Sauer is going to make the administration's strongest case in December, arguing that the president's constitutional authority over the executive branch is plenary and that any restrictions on removal are incompatible with that authority as the founders understood it. He has some powerful arguments to make and some justices who seem inclined to agree with him based on their previous writings and opinions in related cases. But even if Trump ultimately wins the constitutional argument, and there is a real chance he will, given the current composition of the court, the way this is played out has damaged his position in the short term and created a narrative of judicial overreach that his opponents are using against him effectively. The broader context here is Trump's entire approach to reshaping the federal government, which depends on his ability to install loyalists throughout the executive branch and remove anyone who might resist his directives or slow down his agenda. Independent agencies have been a particular target because they have historically operated with some degree of autonomy from White House control, making decisions based on their statutory mandates rather than presidential preferences and political considerations. If Trump can eliminate removal protections, he can ensure that every agency head knows they serve at his pleasure and can be fired instantly if they displease him in any way. That would represent a fundamental shift in how our government operates and would give the president far more direct control over the administrative state than any president has had in modern history. All right, let me break down the key points of this Supreme Court situation so you understand exactly what is happening and what it means for Trump's presidency and for the country as these legal battles continue to unfold over the coming months and potentially years. There is a lot of complexity here, but I want to make sure you walk away with a clear picture of the stakes and the implications, because this affects how our government will function for years to come, regardless of who is in the White House. Point number 1. The Supreme Court has scheduled December arguments on potentially overturning Humphrey's executor, the 1935 ruling that has protected independent agency leaders from at-will presidential removal for nearly 90 years and has shaped our entire administrative state. This is a huge deal because that precedent has been foundational to how our government operates and has been reaffirmed by courts countless times over the decades as settled law. If the court overturns it or significantly limits its application, it would give the president dramatically more control over agencies that have historically operated with independence from direct White House influence. Trump has been pushing for exactly this outcome, and now he has a real chance of getting it from a conservative court that has shown willingness to reconsider long-standing precedents when they conflict with originalist interpretations. Point number 2. Solicitor General D. John Sauer will personally argue the case for the administration, claiming that removal restrictions infringe on the president's constitutional executive authority as established in Article 2 of the Constitution and understood by the founders. The fact that Sauer is handling this personally rather than delegating to a deputy tells you how important this case is to the Trump administration's entire approach to governing and reshaping the federal bureaucracy. Some conservative justices have shown openness to this argument in previous cases and writings, suggesting Trump may have the votes he needs to prevail on the ultimate constitutional question when it comes down to the final decision. But the outcome is not certain, and the legal arguments on both sides are substantial and have been debated by scholars for decades. Point number 3. A recent ruling lets Trump remove the FTC's sole Democratic commissioner, which critics say dramatically expands executive power through the shadow docket without adequate deliberation or explanation of the court's reasoning. This is a practical win for Trump in terms of controlling that specific agency right now and sends a signal to other commissioners across the government about their vulnerability. But the way it happened through an emergency order rather than a full decision after briefing and argument has generated significant criticism and has not provided clear guidance about what other removal protections might be vulnerable to similar challenges. The uncertainty is actually creating problems for the administration, even as it celebrates the immediate result, because nobody knows exactly where the lines are. Point number 4. Justice Elena Kagan wrote a powerful dissent warning that the emergency docket is being used to transfer government authority from Congress to the president in ways that bypass normal judicial process and establish procedures for constitutional adjudication. Her dissent captures the concern that the court is making constitutional law on the fly without the careful consideration these important questions deserve from a deliberative institution. When Congress creates an independent agency and gives its leaders removal protection that represents a legislative judgment about how government should function and how to protect certain decisions from political interference. Kagan is arguing that the court should not override those congressional choices through emergency orders without full consideration of the consequences for separation of powers. Point number 5. This case ties directly to Trump's broader efforts to overhaul federal agencies and remove obstacles to his policy agenda, including economic deregulation and restructuring of the administrative state to serve his vision. Trump has been explicit that he wants to fundamentally change how the federal government operates, reducing the power of career bureaucrats and independent commissioners who might resist his directives or slow down his agenda. The removal protections established in Humphrey's executor have been among the most significant legal barriers to that vision because they prevent him from simply firing everyone who disagrees with him. A Supreme Court ruling in his favor would remove that barrier and allow him to pursue his agenda with far fewer constraints from officials who might disagree with his approach. Point number 6. The case connects to ongoing controversies over presidential overreach, stretching back through the 2024 election immunity debates and continuing into current policy battles across multiple fronts where Trump is testing the limits of executive power. Trump's view of executive power has been consistently expansive. He believes the president should have essentially unlimited authority over the executive branch and should not be constrained by Congress or the courts in exercising that authority, however he sees fit. This case is just one front in a much larger constitutional battle over where presidential power ends and where other branches of government have legitimate authority to constrain executive action and protect their own prerogatives. Point number 7. Trump's fury over recent developments stems from the uncertainty created by how the court is handling this, even as he gets some favorable rulings in the short term that give him immediate wins. He thought he had the constitutional argument locked down and that courts would simply agree that removal restrictions are unconstitutional and let him fire whoever he wants without any pushback. Instead, he has gotten a messy situation where he wins some battles but faces ongoing litigation and uncertainty about exactly what he can and cannot do until the Supreme Court issues a definitive ruling. For someone who values control and certainty as much as Trump does, this kind of legal limbo is infuriating even when the overall trajectory seems to favor his position in the long run. Point number 8. The outcome of the December arguments could reshape the relationship between presidents and federal agencies for decades, affecting every future administration, regardless of party, and fundamentally altering how our government functions at the most basic level. This is not just about Trump, although he will be the immediate beneficiary or victim, depending on how the court rules on the constitutional question. Any precedent established here will apply to future presidents of both parties and will shape executive power long after Trump leaves office. Democrats who oppose Trump's expansion of executive power should recognize that a future Democratic president would inherit the same expanded authority if the court rules in Trump's favor, which is why this matters beyond the current political moment. So where does this leave us as we wait for the December arguments and the eventual ruling from the Supreme Court on these fundamental questions of constitutional structure and presidential authority that will shape our government for generations? It leaves us with a president who is furious about the uncertainty even as he accumulates wins on individual removal questions. It leaves us with a legal system struggling to apply precedents that may be overturned at any moment by a court willing to reconsider settled law. It leaves us with legitimate concerns about whether the court is making these important decisions through appropriate processes that allow for full deliberation. And it leaves us waiting to see whether nearly a century of understanding about independent agencies will survive this assault or be fundamentally transformed. This is exactly the kind of constitutional moment that shapes American government for generations. And most people are not paying attention because it seems technical and boring compared to the daily political drama that dominates the news. But what happens in December could matter more than almost anything else this administration does. The structure of power in our government is being contested in real time, and the outcome will affect how presidents govern and how agencies operate long after Trump is gone from office. I will be following every development and breaking it down for you as this case proceeds through the courts. Make sure you are subscribed so you do not miss the arguments in December and the ruling when it comes down. This is history happening right now, and you need to understand what is at stake. I will see you in the next one.